Good afternoon, everybody. Keith here. Hoping everybody's having a good day. Enjoying life, living life, loving life. Wanted to get on today and talk about documents in the form. And hopefully I'm conveying this right, because all I can go upon is my own experience. Granted, there are some cases out there that I know of that people have won, and they tell me about all the different people they've noticed and everything throughout the process. And from what I gather, it's all about copyright, trademark, origins, things like that. And the process of the Postal Service is actually a copyright process. And so I want to go through and I'm going to explain some of my documents here that I'm getting ready to do for my companion. We have certain people, and most everybody has a some kind of relative experience with debt collectors. And so that's what we're dealing with right now, is an attempt to collect a debt by somebody that bought the debt from somebody else, which was a bank. A bank, once it sells a debt, relieves the debtor of liability presumed. Remember, folks, liability in this commercial world, as far as it's concerned, is always presumed, because it's stated in on and for the record that the authorized representative giving the unambiguous authorized signature is not liable for the person named in the instrument for the signature on the instrument. It's very specific wording. It tells us we're not liable. So liability in the commercial sense in these courts, when they're projecting that you're liable, is false. Period. Right from the start. So every case that they bring in court for debt collection, where you signed your name to any instrument, is a presumption and a false claim. Period. It's false right from the start. Failure to state a claim upon which relief can be granted because the liability is not by the signature. States right in their Uniform Commercial Code. If you're authorized and giving a signature under that authorization, you are not liable. On any instrument of the United States, whether it be used in a state of the Union or in the United States, is an instrumentality of the United States, and therefore they are obligated, not you. Period. Plain and simple. That's the way the law reads, and that's the way you should assert it. Period. So, let me turn my camera around here. And as you can see, we got 3 envelopes. We have 1, 2, 3. We have a sheet that's got some addresses on it, one for each envelope. One is going to the one claiming the debt. One is going to the court that is administrating over the proceedings. And one is going to the U.S. Department of Justice, attention, U.S. Attorney William Barr. Okay? Now, each one of these packets has identical information from start to finish, and each one of them has one of these. And you'll notice there's 3, and I said that each one of these already has one of these certificate of mailing posted service. This one here, each one of these has their own copy that's going to be signed. And this one here is the original. It's going to go to the one that's serving it. This is going to be their original copy. I have an original copy, or the original actually, in the electronic form through the emails. That's my copy. And those all have security certificates attached to them in the electronics through the programming. I'm going to set this down and open this packet up. Now this is the last packet. And as we see, and I posted this in my Facebook group here a few days back. It says cross libel, case number. And you notice that case number is not the same as the case numbers they brought. This is my case number. This is a case number I developed. And actually, it's just a timestamp. That's all it is. It determines, it's telling us when I started constructing this in entirety. It's the beginning of the construction. It's the origin. It's a timestamp when I started, so that when we insert the fee schedule, we can show we at least started it there, and logically and reasonably we can assert certain time spans that it took to research and put this paperwork together for fee schedule purposes. So it's dual. It works as a timestamp because it is a timestamp and a case number deriving the origin. And notice it says right away we start out in the Admiralty jurisdiction, our court of inherent jurisdiction. Notice it says our, and it says all assumptions waived, meaning that we are not going to assume shit. We are going to question everything, no matter what you presume. And then, of course, we've got the case, and notice it says Joyce A. Schmidt. That's the way they brought it. And then it says Schmidt, Joyce Ann, sui juris, impropria persona. And it's got Iowa District Court for Black Hawk County, small claims numbers. So you see they took us small claims. Demand to dismiss cross libel in brief in support thereof. Complaint, claim in Admiralty. Controlling throughout. Mistakes are forgiven. Rule of law is substance and not form. Period. It is not form. So when dealing with these guys, I want to show you. These are all separate papers, right? This is one form. This is like letter form, okay? We'll put this down. I'm still here despite the dark screen. Okay, now that was the third packet. This second packet is identical to this one. This one, however, is different. This is the one that's going to go to the court, and through the registered return receipt, registered mail and green return receipt, you're going to notice right away off the bat, there's a difference if you look close. What is that along the side? Guess what, folks? That's a book. That's not letter form. That's in book form. Look, if I pick up the first page, the whole thing comes up because the binding has been bound. It is binding. Period. Okay? Comprehend that. Okay, now we're going to go to a signature page here. Okay, this is the last page of the original document of the actual claim in Admiralty. You'll see it says respectfully submitted, authorized representative of Joyce Schmidt. There's no line, there's just going to be a signature. Notice it's on the right hand side. Authorized representative, right hand side. Down here we have expressly Joyce, full colon, Minaj Schmidt. Minaj. Where does Minaj come from, folks? Management. Joyce, management of Schmidt. Grantor. Grantor. Trustee. Guess what? Beneficiary. Get it? Okay, now another thing I want to point out, and you'll notice it says here, in the construction of this, it says respectfully submitted by, and then it's authorized representative Joy Schmidt. It says State of Iowa, Black Hawk County. Right here, we're going to fill in address information. It is not on this document, but we have to include the address information, and that's where we're going to put it. We're going to put it in ink, handwritten ink. And then it says this is the jurat. This is the acknowledgement of what's in this document under her signature, and then a notary public for the people of, and we're going to put Iowa Republic. Down here it says commission expires. The verbiage here is important, folks. We need to comprehend one of the ways, just like this here, it says Minaj Schmidt. One of the ways to get these people to pay attention to your documents is by not using their verbiage. Now, granted, in a lot of this, we have to use it in accordance to their statutes, codes, rules, and regulations to get them to find it. But when we're making other private statements, and I'm going to show you here, it says Joyce or Schmidt, Joyce Ann, the cross-libelant, aggrieved, being with providence of grace. With providence of grace. Look that up, guys. Find out how important that is. And then notice it says, quote. Quote. See the little quote mark? If you stand before any court presenting documentation, this is the only part you should ever verbalize in that court, stating that they need to refer to any of their questions to within the document. If it is not covered in the document, then you ask for leave of court to come back with appropriate response. Otherwise, you stick to this statement: I have read the foregoing, demand to dismiss and cross-libel in brief in support thereof, cross-libel claim in admiralty, and do hereby asseverate. Asseverate. It's the same thing. It's saying that what here is true. What here is said, what herein is said is true. It's the same thing as saying affidavit. This is not an affidavit. This is not an asseveration. This is all of them. This is all of the truth put together. Their facts and your facts put together to give complete closure to the case, leaving no stone unturned. That way, like I said, if they ask you something that's not in the document, I ask for leave of court so I can come back and give appropriate response. If it's not addressed in the above, then I need time to go do some research, which of course is going to cost you according to the fee schedule. Here, let me show you the fee schedule. Oh goodness, look at that. $250 a page. This is a lot of pages here, folks. Oh, look at that. $500 an hour for research, review, and responsive communications. Guess what? Depositions and interrogation unsolicited. Each one of these proceedings, each proceeding is a deposition, interrogation. They are trying to depose you. They are trying to move you. They are trying to take your position and move it so you cannot fend for yourself. It is, in fact, a deposition. $50,000 if you want my appearance, baby. So think about this stuff, people. So then we're going to go back to this, finish up here real quick. So then it says, asseverate that the contents thereof are true. The use of a notary on this document does not constitute any adhesion, nor does it alter my status in any manner. Period. The last one here, folks. This is very important. This is something they use on international bills of exchange. Done in good faith. Given with patent right. In other words, if you look up the word latent and what people pronounce as patent, it's actually patent. Just like latent. Latent is underlying. Patent is overlying. This is the principle of the copyright in form. It is overlying. It precedes on top of all other records. Period. So this claim right here overlies all other documentation presented in that court, because all other documentation presented in that court is not presented in the proper form. Now these here going to William Barr and Portfolio Recovery Associates, these are in letter form, because I don't give a rat's ass about them. I don't give a rat's ass about anybody bringing a false claim. However, when it comes to the court's going to get this one. And they better pay attention, because now if they refuse this, now the claim is going to be asserted against them. In this cross libel, I am giving them the opportunity to do what they're supposed to through their judicial discretion. And if they don't, immediately dismiss and allow for the cross libel to continue in the federal courts under the bankruptcy statutes that I've listed in here to clear up for further corrections of the records. See, we've noticed a mistake on the record, okay? So we're pointing it out now in this case. However, in finding out there's an error in this record, it points to the fact in, on, and for the record that there are more mistakes in the record, because the mistake made on this record was due to inherent signatures giving before on other documents. And therefore the presumptions that were brought forth in this record may also be brought forth at some point in time in the future through other debt collectors trying to do the same thing. So now, if we have an ongoing ancillary case in federal court due to one that was brought in a state court, and somebody else steps in and wants to make claims similar, oh, gee, thanks. I'm going to add that into this case. I'm going to call in all debts and add them to the federal case. And like I said, if the local court doesn't wish to apply the discharge and proceedings in federal bankruptcy courts, then we assert the claim against them as well. We insert them into the claim, and we send another notice to William Barr and the state attorney general. That will be our next step. We're not going to include any of these other people if this court does not act appropriately. We are then going to move straight to federal. Period. I don't care about administrative exhaustion. We already tried to do the administrative process through portfolio recoveries. In the first notice, they turned around and hired an attorney and sent it to the courts. Now, if the courts turn around and don't accept it, that shows us they're also blatantly avoiding the administrative process they're supposed to follow under Title V of the United States Code. And that's what we'll assert. That's what we're going to assert. Because along in that claim, that declaration was made that we did make an attempt through the administrative process, 1, 2, 3 notices, but upon the first notice, they conspired with a third-party intervener known as Blitt and Gaines, private attorneys, and brought the case through a representative. That's conspiracy to commit fraud. And then when they actually brought the fraud to the court, that is fraud upon the court. Now, if the court wants to act upon it, then that's fraud against me by the court, when it is specifically their duty to prevent that fraud. And I do, and like I said, this is my companion, this is paperwork for my companion. So yes, it is fraud against me. I am the grantor of her and her trustee. She is the grantor of myself and my trustee. So any claim brought against either one of us is brought against both of us. Comprehend this stuff, people, and realize form doesn't matter so much in their realm, but that's one of the things you can use against them. So when we talk about that form, is it letter form with no binding so that each sheet can be separated, maybe turned around and switched up, make it more confusing? That's letter form. Book form. And it was published. Now, it was published and offered to a private entity. And like I said, patent rights. If they deny it, guess what? It gets published publicly. Anybody want a copy? Let me know. But of course, you'll have to wait until after the court proceedings, because only the court proceedings will determine whether this goes public or not. That's form, folks. Anyway, hope you enjoyed today's little video. If anybody thinks I'm wrong in any of this, and notice I didn't put stamps and stuff like that on there. We're going to do that with the registered mail and certified return receipts and stuff. Like I said, that's done through electronic certificates, security certificates in the electronic. So everything I've done electronic is already an original. At a later time, if need be, I can do the stamp things. I can do the, and in fact, we're actually going to do the blue ink signatures and the red thumbprints for the documents, but we aren't going to use any homemade stamps or postage stamps or anything. That's a stamp. That's a seal. Okay? You don't have to produce a stamp. You can make your mark on the spot. You could technically, just like they say, mark an X, you could technically draw out the same thing and make it an exquisite simple symbol, like a Chinese symbol even, and have all kinds of different marks, and nobody would be able to read it but you, because you know the original form. And that technically is a stamp. That's the way you seal your documents, and everybody has that right to be the first one to seal their documents, or to notice their documents with their seal. So think about that stuff. Mark their documents with their seal. Seal their documents with their mark. Synonymous. So think about this stuff. And again, like I said, I hope this stuff helps you. In the meantime, when I get done here, I'm going to post my other forum links and my PayPal link. Please help if you can. Please spread the love in all ways, whether it be just the PayPal link or just sharing this video. Sharing my links as well, whatever you want to do. Be involved. Help me help you. And remember, folks, if it wasn't for you guys, I wouldn't be doing this. God bless. Love you. Have a great day. Bye. Get involved.